Check.
Again.
Check.
Again.
Check.
Okay, so I already have one. That's not been able to get on.
Our entire website is down?
We're setting up the link to the YouTube channel.
You have got it.
No, I'm not.
As much work as you put into it.
Yes, I'm about ready to quit, but it's okay. Okay, I'll wait till 5. I'm just kidding. It'll be
Please
our,
wait until
yes.
2 weeks from now, please, come on.
All right, okay. I'm giving you 2 weeks. That's it. I'm just kidding. I need like 12 years.
Microphone turned on.
Hang on just a second. Okay, go ahead and get Tom set up.
All right, I'll wait on my instructions. So you want me to turn it on?
Hello.
You're good.
I'm sorry? I didn't hear that. We ready? Can I start? All right, great. Today is lobbyist training. I understand we've got about 27 people who are attending via webinar, and we've got 5 people here in the room today. I appreciate all of you showing up today for the training. My name is Tom Albritton. I'm the director of the State Ethics Commission. And this training will take roughly about an hour, probably a little bit less. We have provided a phone number for you to text questions to should you have them. We generally handle those questions at the end of the presentation to see if the presentation answers the questions that you might have as we go along. But as you have questions, just text them to the number, and then we will gather those at the end and address them as we need to. I think all of you have the number that's running on the bottom of the webinar. However, this is just a reminder. If you do not have that number, you can't see it. And for those sitting in the room, this is my number. This is my cell phone number here at the Commission. And so if you have any questions that come up after the training today, just know that you can call me at that number, or you can call me directly at the Commission. What we tell you today is the floor, not the ceiling, for ethics compliance. This is just the bare minimum requirements. We also don't expect you to memorize everything that we go over today. So I want to remind you that your contact at the Commission is Vicki Manning. Most of you have probably already had some contact with Vicki, if for no other reason, with your registration and also signing up for this. But Vicki is the first one you should go to if you have any questions. And generally, what you're going to have a question about is not so much what is allowed by the ethics laws, but how you comply with various reporting requirements. And she is certainly the one you would talk to about that. If you have a question, you can ask her. She will then talk to me and the General Counsel about it, and we will, through the 3 of us, will get you the answer that you need. But remember, Vicki is your contact. Now, our Commission is actually made up of 5 people. I'm not the Commission. I work for the Commission. Our chair for the Commission is Beverly Brady. She is a lawyer from Auburn, Alabama. We also have John Plunk, who is a lawyer from Athens. Have Justice Lynn Stewart, former Chief Justice of the Alabama Supreme Court. Stan McDonald, who is a lawyer in Huntsville. And then our newest member is General Ed Crowell, a retired brigadier general from out at Maxwell. And he also worked with a defense contractor after that called Miltope. He is our only non-lawyer on the Commission. This is General Crowell's second time to serve on the Commission. Each of our commissioners serve staggered 5-year terms. So every year somebody's rolling off and somebody new is coming on. You need to know who these individuals are, because they are the ones who make all the official decisions for the Commission. So if there is an administrative rule, they have to approve it. If there is an advisory opinion we issue where we are defining certain areas of the Ethics Act, they're the ones who have to approve those opinions. If there is an enforcement action that is filed against an individual, then they are the ones who will weigh the evidence and determine whether there is probable cause for a violation. So they're the ones who do all the official work for the Commission, and the staff works to prepare them for the meeting. So although I'm the only one who's directly employed by them, all of us work toward eventually getting stuff to these folks to answer. The advice opinion process that we've got is something that I encourage you to take advantage of. If you have a question about whether certain conduct is allowed under the Act, whether there are certain things you can give to an elected official, or whether you can host certain receptions or parties, that sort of thing, you can ask us, the staff, for an answer to that question, and we can give you that answer through what is called an informal opinion. We give roughly over 1,000 informal opinions a year, which is a great deal of advice that we're giving out, and you can certainly take advantage of that. The method for doing that would simply be to email us at the email address we have listed on our website for questions, and then your question will be reviewed by the Assistant General Counsel in our office, who is Brian Patterson. He's the young man sitting in the back corner of the room. Cynthia Ralston, who was at the front of the room, who is our General Counsel, and me. The 3 of us roundtable every informal opinion before it goes out. So before the answer is given, the 3 of us will have batted it around back and forth before we give the opinion out. You can also request a formal advisory opinion from us. Those are 2 different kinds of opinions that we give. A formal advisory opinion is a question that is answered by us in a written public document that generally is going to answer a question that we have never answered before. In the lobbyist world, the best example I can give you was an advisory opinion that we gave out in 2018, where we answered a question, I believe it was 2018, the years are going by quicker and quicker, but I think it was 2018, where we had a question that was asked about how certain expenses should be reported in your report that is submitted to Vicki Manning, and whether certain expenses could be split up among different sponsors and that sort of thing. And so we answered that question for the requester because it had never been answered before, and it was not clearly spelled out in the Code of Alabama what the answer was. So when we give a formal advisory opinion like that, we are generally defining an area that has not been analyzed before. A formal advisory opinion also gives the requester legal protection for the conduct that is referenced in the opinion, as long as you rely on the opinion within the advice that's given and you gave us all the correct facts, et cetera. You didn't misrepresent anything to us when you gave us the question. And not only can you rely on it, but anyone who is in a materially similar circumstance can rely on it as well. We give far fewer formal advisory opinions than we give formal advisory opinions. The informal opinion, though, does not give you legal protection. However, an informal opinion is a confidential question. It is confidential by administrative rule. Okay, does anybody have any questions about our opinion process, or what you should do if you have a question? Okay. The only other thing that I would tell you is that informal opinions or formal opinions can only be prospective in nature. You can't ask us about something that you already did and ask us if that was okay. We cannot answer that question. We can only answer prospective questions. So if you have a question or if you're unsure about something, ask well ahead of time and ask often. We don't mind if we get asked the same question over and over again, or if the answer we give you is unclear. We want to make sure that you understand the answer, that we understood your question when we answered it. So if there's any disagreement at all about that or misunderstanding, we want to clear it up on the front end. Now, I do have to talk about the complaint process and our enforcement procedures a bit, because they are part of our act. The Ethics Commission is in charge of enforcing a criminal code, and if there has been an allegation made that there's been a use of office or personal gain, or that a lobbyist offered a thing of value to a public official that they could not offer to a public official, or that a public official solicited that, or that anything was given to a public official in order to corruptly influence their official action, then that kind of conduct can be the subject of a complaint that is filed with us. If a complaint is filed with us, then the process for that is that the Assistant General Counsel and the General Counsel will review the complaint and first determine whether it even states a violation of our act. If it doesn't state a violation of our act, we will either dismiss it upon receipt of the complaint, or we will seek additional evidence from the person who filed the complaint. And every complaint has to be supported by credible and verifiable evidence. Every complaint has to be in writing. Every complaint has to have a name on the bottom of it. We can't take an anonymous complaint from anybody. We can't consider those. We were prohibited from doing that by law. But if the complaint states a violation, it is supported by credible and verifiable evidence, then we will assign the case to one of our investigators. The investigator will have 180 days in which he or she can complete the investigation of the complaint. At that point, once the investigation is complete, and all of our agents are APOS certified, we can subpoena documents. They have full subpoena authority, the commission does. And after they have subpoenaed documents and they have talked to witnesses, they will then present their case to the chief investigator, who will review it. If he believes that there is sufficient evidence of a violation, he will then present it to our general counsel, who will likewise review it and make her independent assessment of the case. She will then present her recommendation to me, and I will either disagree with it or agree with it. But it's important to know that before a complaint gets presented to our commission, it has gone through that multi-level review by the legal staff at the very beginning, then the agent who has investigated it, then the chief investigator, then the general counsel, and then me as the director. And then if we are on board with it and think there is more likely than not a violation of our complaint, we will present it to our commissioners, who sit as a grand jury of sorts and will weigh the evidence and determine whether there's probable cause for a violation. If they believe that there is probable cause for a violation, then they will refer it either to the Attorney General or to the District Attorney in the location where the act occurred. And then that enforcement agency can do whatever they want to with it. They can present it to grand jury, they can dismiss it, they can send it back to us and request that a fine be imposed in lieu of a prosecution. It really becomes their baby at that point. But it's a very deliberative and multi-layered process before it even gets to our commissioners. And if you will remember the biography of our commissioners, 4 of them are lawyers, and 1 of them a former Chief Justice of the Alabama Supreme Court. So these are folks who are used to weighing evidence, listening to testimony, making legal decisions, interpreting statutes, all of that. The issues could not be in 5 better hands than they are currently in. And General Kroll, even though he's not a lawyer, has served on the commission for 5 years prior to coming on this most recent term. But he also has a lot of practical experience about what these decisions look like out in the workforce for businesses who deal with government. Because remember, he was with a government contractor when he left. So he's no stranger to how these rules affect decisions in the business community either. Intentional violations of our act are felonies. They're Class B felonies, punishable by between 2 and 20 years in prison. All other violations are misdemeanors. Intentional violations have a 4-year statute of limitations. Our misdemeanors have a 2-year statute of limitations. Any questions at all about what I've gone over so far? I think it's pretty straightforward. I'll be honest with you, we really don't see lobbyists come in front of us on our complaints. That doesn't mean that people don't complain about lobbyists. I mean, other lobbyists will call and they will complain about you to our office, but generally it's something about your registration, or it is something that they believe that you might have done wrong, but rarely will anybody actually file a complaint over that. And as I told you, we cannot consider oral complaints, we cannot consider anonymous complaints. So it's got to be a written document filed by somebody. The best way that you can keep yourself out of trouble on the easy stuff is make sure you communicate with Vicki. And so if you've got to update your registration, if you've got to add somebody new that you're lobbying for, just make sure you do that, because that's where people get, not really in trouble, but that's where they get complained about, is when they're over there lobbying for somebody that doesn't match up with the registration that's available on our website for anybody to view. And the public can do that. Now, the lobbyists can do that. They can see your registration. They can see who you're registered to lobby for, the subject matter that you're lobbying for. So you just got to make sure that what you're doing is consistent with what has been filed with our office. The other thing that you need to make sure you do, and I will remind you of this toward the end of it, is to make sure that you communicate with your principal so that they have confirmed that you, in fact, are their lobbyist, because until they confirm it, you won't show up as having registered. And that also causes some problems once we get into session. If your principal hasn't confirmed you, somebody will say, so-and-so's over here lobbying and they haven't registered with you. Every time that has happened, I've gone to Vicki, and she's like, they have registered. The principal just hasn't confirmed it, but they will. And I will tell you, and Vicki knows these folks, and Vicki will say they will confirm it in about 2 weeks, but they are going to confirm it because it tends to fall into patterns. However, you could help Vicki out a lot and yourself out a lot if you will kind of ride the principal about confirming it and staying on top of that. That would help you out immensely in the long run. But those are the easy things you can do to stay out of trouble. Just communicate with Vicki, make sure you're disclosing, make sure that you are updating what you need to update. Any questions about any of that? All right. Now, the overall theme for the Ethics Act is that no public official or public employee can use their position in a manner so as to benefit themselves, their family, or any business they're associated with. Everything else under our Act falls under some variation of that overall theme. For you specifically, there is a provision in our Act that just presumes certain conduct can set up relationships that can lead to a use of office for personal gain or to have some kind of corrupting influence on a public official. So the legislature put a provision in to the Act that says that you cannot offer nor can a public official solicit a thing of value from you. Okay? Now, a thing of value is defined as any gift, benefit, favor, service, gratuity. It's a rather large definition. It includes football tickets. That definition is not unique to Alabama. Those words find expression in any number of ethics codes, federal and state. So this idea of thing of value is something that is generally known in the lobbying community to mean a certain thing. More often than not, it means something that has a monetary value attached to it. But there are circumstances in which something that is not, doesn't have a price tag attached to it could be a thing of value. It does have the word favor in the definition. So what you need to remember is that the general prohibition is that you can't give stuff to public officials and they can't solicit stuff from you. Now, there are about 18 exceptions to the definition of thing of value that encompass most of the stuff you're going to want to do on a daily basis or a weekly or monthly basis. For example, you can have legislative receptions. There's a specific provision that allows that. You can take legislators out to dinner within certain limits. Lobbyists have a $25 per meal food allowance with an annual cap of $150. Your principal has a $50 $250 limit. However, if the meal is part of a widely attended event or an educational function, then those limits don't apply. So the food limit is something separate. There are items of de minimis value you can give. De minimis is defined as less than $25. In conjunction with a widely attended event, you might have a swag bag that's got promotional items in it. If you think about the League of Municipalities may have something down at the beach, and they will have a bag that they give to all registrants that may have a bottle of water that's got Orange Beach, Alabama on the front of it, maybe some suntan lotion and some sunglasses, that sort of thing. All of those kind of gifts in conjunction with an event like that are allowed. They're specifically allowed under the Act. There's a friendship exception within the Act that allows people who have been friends for a long time, certainly for a period of time that preceded the public officials' advent into the public sector, then gifts, just as they have been exchanged between those parties historically, can continue to be exchanged. Family members can exchange gifts between each other. Transactions within the ordinary course of business can still be conducted as long as the terms are commercially reasonable and the facts make it clear that it's unrelated. Anything that's being solicited or given is unrelated to the public official's official position. Can still be done. So what you can see is that there are any number of exceptions that will enable you to continue to do your job effectively and at the same time not violate the Ethics Act. Now, I want to give you a cheat sheet for all of those events that I just gave you. If you go to our website, there is a banner at the top that's got a tab for pre-certifications. A pre-certification is an act that I do where a lobbyist or a principal asks me to approve a certain event, a legislative reception, a dinner for two committees, one from the House and one from the Senate, who are going to be discussing health care or insurance regulation or whatever. And when they request our approval for that event, I may have some follow-up questions, but eventually I'm going to put a stamp on the front of it that either shows that I've approved it or I have denied approval for it. Those letters are public records and they're accessible by you. You can review them. So if you have never put on one of these kind of events, you can use those as a guide. You can look at the letters that have been filed previously, and we've got them going back a number of years. You can look at what people have filed and you can see what we have approved. And so I think it makes it a little bit easier for you. It makes it easier for us too, because you will have kind of gone through the motions of what's allowed. And if it has been pre-certified, it's on our website, then it is allowed. So you can use that as a guide. You don't have to get anything pre-certified by us. We don't have to give approval ahead of time. However, I think it's a helpful tool. I think it also provides some comfort to the members of the legislature who may be invited to these events to know that it's at least been cleared by us. And they all tend to fall into the same pattern. And once you kind of get into it, is everybody here, I guess, new to lobbying? But are you new to lobbying just in Alabama or everywhere? Is anybody registered in another state? Okay, so this is your first rodeo with it? All right. Well, as you get into it and you hear people talking, some of this will become clearer too. But if you're unsure, call Vicki or call us and we will tell you kind of what the process is. Okay, just know that yes, there are ways that you can that you can have social interaction with these public officials in a way that doesn't violate the act. What you have to avoid is the obvious stuff that if you never did training, you would know you couldn't do anyway. All right, you can't just give them money in order to get them to do a certain official thing. Okay, and if you did not know that that was a problem before you came in here, remember that when you leave, that you can't do that. All right, but I've never met anybody yet who didn't know that that was something that you couldn't do. So you can't do that. You can't offer certain things like jobs to family solely for the purpose of getting some official act out of somebody. So anytime you're going to be, if you were tempted to offer something in order to get an official action out of somebody, you're probably in some dangerous territory. And if you think you might be close to that, or that somebody could argue that you've done that, then ask us the question. That's what the informal opinion process is for. I've gone through that. I've gone through that. Any questions about what I've gone over so far? Okay, I'm going to turn it over to Cynthia and let her pick up where I left off, and then I'll come back toward the end. Any questions online?
No.
Okay.
Okay, so Tom, all right, so I'm Cynthia. The lawyer, or I was the lawyer, but now we have another lawyer. So I'm now just a lawyer. Anyway, so Tom covered a good bit of the pre-certification stuff, so I'm going to kind of flip through it, but I want to kind of put it into context for you. When he talks about pre-certification, he talked about the 18 exceptions to a thing of value. Okay, so you can't give a thing of value to a public official or a public employee. But there's 18 exceptions to that. The pre-certification is one of those exceptions, as is a widely attended event, which is, a gathering of 12 or more people of different interest. And so we can pre-certify a widely attended event, which are both independently exceptions to the thing of value. Okay, all you're trying to do is get around providing a thing of value to a public employee or public official, all right? So that's your goal, to avoid violating 5.1. So he talked about the definition of thing of value. These are the three things that really apply to the pre-certifications. I'm not aware of anything we've pre-certified that is anything other than a widely attended event or an educational function.
Maybe an economic development function.
Right, but it's up there on the screen. But anything else?
Well, we have. We have pre-certified as part of that the giving of promotional items.
Yeah, the giving of things, right.
Or de minimis. We have pre-certified certain events, not as widely attended events or educational functions, but as falling within the de minimis category for food. Those are really the only other things that I can think of.
Yeah,
Those three biggies are going to cover nearly anything you would want to do outside of some kind of random part of an event or something kind of novel.
Right. So generally, this is what you're looking at, okay? The widely attended event is defined in our act, so I won't read it to you verbatim, but it's essentially a gathering of 12 people with diversity of views or interests. That doesn't mean you can't have 12 accountants in the room, okay? 12 is really just a number that they came up with to say, it's somewhat arbitrary, I think, but that says if you've got 12 or more people, generally those people are going to have a diversity of views, even if they all happen to be accountants or lawyers or lobbyists, okay? Educational function is just what you think it is. You go to a conference, you go to a seminar, you get materials, somebody talks to you sort of like this, you listen to it, and you go home. So that's an educational event. Economic development function, same thing. Its primary purpose is for economic development. And all of these terms are defined in our act, and if you're seeking a pre-certification, I would just kind of reference those and sort of do a checklist of, have I covered this, have I covered that? Transportation and lodging. So what is allowed is also contained within the definitions or the exceptions in the thing of value. Because I say that, so they're contained in those exceptions. So what can you provide? You can give transportation and lodging to our widely attended event and an educational function for actual and necessary expenses, all right? It is not an actual and necessary expense for somebody to stay 3 days longer than the conference or the widely attended event lasts, all right? So that's going to have to be, and we will ask those questions, and it may seem tedious, but we need to know what are you actually paying for and what are they actually attending. And then they have to have meaningful participation. They can't just show up. They have to be a speaker or panel participant, presenting information related to their agency, performing a ceremonial event or function, and it's appropriate for their official responsibilities. Also, you can have transportation and lodging for economic development function, but spouses are not included in that. So that's a distinction you'll want to pay attention to. If you get to the pre-certification stage, you can ask us, and we can piece that out for you. Hospitality exception, you can have that for a widely attended event, educational function, and economic development function, and spouses are included for this. It's food and beverages as an integral part. This is apart from the food and beverages that you're allowed to provide individually to a public official or public employee. Okay, so a lobbyist can give $25 to a public official, public employee. This may or may not go beyond that, but if it's a part of the widely attended event or educational function, then you may be able to provide more than that. Okay, so that would be part of the pre-certification. And as I said, this is what Tom discussed already. The lobbyist can provide $25 a meal, up to $150 a year. That's 6 times. And then for a principal, it's $50 up to $250 a year per public official or public employee. Okay, so this is sort of a checklist and this is contained in the statute. So you got to make sure it's a meeting, an event, or activity. It's organized around a formal program and agenda. There's educational or informational speeches, and then it's concerning something within the scope of the participant's official duties. I don't think probably something about engineering would be within the scope of my duties because I am not an engineer. This is to be sure. All right. And then a widely attended event, as we said, a gathering, dinner, reception. Reasonably expected that more than 12 people will attend. This would be a legislative function, a legislative luncheon or reception or something like that, and a diversity of views. And it cannot be, and I'm going to get into advisory opinions that give you some structure and context about this and examples, but it can't just be that you take a bunch of people hunting. That is not a widely attended event, independent of some other, formal structure around that. What we're going to need to know is we need a list of the people that are invited. If it's under 50 people, a sign-in sheet, and then how many people do you expect to attend? And so obviously we have to have that to assess whether or not more than 12 people with a diversity of views are invited. And then tell us what you're paying for. Actual and necessary expenses, what type of transportation, what type of lodging. If you're having a nice, a seminar at the Holiday Inn, and it's going to matter maybe whether or not you're putting the person up at the Omni or something, right? So we want to know what transportation you're providing. Are you waiving any of the registration fees or similar costs? That's okay. Just tell us what you're doing, and then who is it and who's attending, and what are they doing? We talked about that. It has to be something associated with their position. An integral part. It can't be standalone, as we discussed with the hunting. It has to be in conjunction with the event. All attendees must be invited and sanctioned by sponsors of the event. The best example to give you about being an integral part is a reception on the day that you have registration. So you show up, you register the event. There's a reception that evening that has drinks and dinner or whatever, snacks, and then the next day the conference starts. Okay, that would be considered an integral part. All the attendees are invited. They're not just 3, public officials that get to go to the fancy dinner, but everybody's invited. Okay, I don't know if Tom mentioned this or not, but you have to make the request more than 10 days before the event. That's an administrative rule of ours that we have to follow and do follow. Just because you might have asked for it too late doesn't mean that it's not a permitted event. It just means that you won't have our pre-certification. And I will tell you, if you've not done this before, the reason the pre-certification is helpful is for public officials and employees to know that they're able to go without a problem. Because we have public officials, especially this season was very different, obviously because of COVID. But in the summer, we have lots of pre-certifications because people are going to the beach and they're, entertaining people. And public officials will call us and say, hey, is this not pre-certified yet? I'm not going if it's not pre-certified. That's not to say that you won't have people come, but that is something that they look to as reassurance that they're not going to get in trouble. That's our website. Okay, these are some opinions that you might want to write down. They're available on our website. As Tom said, when you go to the website, actually, there you go. Oh, no, it doesn't have all the tabs, but there's a tab that says advisory opinions, and you can go in and look by number. It's not the most user-friendly search, but you should be able to find it with the number, okay? But if somebody is taking, like if a lobbyist in principle wanted to take me to lunch, which is unlikely and has never happened, but they can't each pay, the lobbyist can't pay $20, $25 for my lunch, and the principal pay $50 for my lunch. They can't stack their expenses. Whoever's going out to lunch, the public employee or the public official, can only receive one sort of payment for their lunch. Does that make sense? Even if you're talking about different issues, it doesn't make any difference. If this principal or that lobbyist, then they're talking about different things with me. It doesn't matter. I'm not getting $75 worth of a lunch out of it or dinner. De minimis, we don't have de minimis lobbying. You either are lobbying, you either satisfy the definition of lobbying and you have to register, or you don't. Some states have de minimis lobbying, we do not. This is the same thing. They're no longer, you can't go on a hunting or fishing or whatever, scuba diving event that's not a part of another event, all right? This is just a continuation. This is in the advisory opinion, we articulate that it has to be an integral part of the event and that all members are invited, and it can be a dinner and food and drink and all of that. But it needs to be around when no other conference activities are taking place, consists of individuals attending the event, and it's sanctioned by the sponsors of the conference. This is the opinion that Tom was talking about, 2018-01, to Al Agricola, which says, I think that's right. Is it Agricola?
No, it was Billy Canary.
Oh, that's right, BCA. Okay, so you can aggregate the expenses, but we're going to have to know who's paying for what. You can't have a sponsor that pays $10,000 and somebody who pays $250, and then nobody, it's not identified who's doing what with that money. So, and then this is the Al Agricola. So this is this is about 3625 1.1. The legislature in 2010 expanded the definition of lobbying, but they didn't do it in the definitional section of lobbying where it is already defined. They added a section to the code of 1.1 and had an additional, in addition to lobbying, that is that if you can't sell, let me think of the language. I want the language exactly. Hold on. Is it in here? No, the language is not in here, but it's that you are promoting or yes, promote or attempt to influence the award of a grant or contract. Thank you, Brian Patterson from the back, our Assistant General Counsel. We did a good job hiring him. So if you're doing that at the state level, you are lobbying, and you would have to register as a lobbyist. If you're doing it at the local level, you are not lobbying, and you do not have to register. Okay. All right, we have a website. This is really an old picture of the website, but our website is pretty good. It's handy. You can find all kind of information about pre-search, advisory opinions, our forms. We have a statement of economic interest that have to be filed. We have all sorts of public documents. We have, because contracts, if a public official or public employee is benefiting from a contract that is paid in whole or in part with state, county, or municipal funds, they have to file that contract with us. You can find those on our website. And Tom has parting thoughts, I think.
When do I not?
He does a lot. But also I do too.
I've got a couple of questions.
Oh, okay.
I'm having trouble seeing that button over my gut, but I'm having to look over. All right, so these are the takeaways, and again, you need to remember everything that we've talked about here today. But for practical reasons, day in, day out, these are the things you need to remember. Remember to update your registration within 10 days. That's by statute that you have to update within 10 days. Communicate with your principal. Make sure you are talking with your principal and make sure that they are confirming with us that you are their lobbyist, and make sure that if you've got more than one principal, that you have talked to all of them. Remember your quarterly filings. Remember to review them yourselves. Often, a lobbyist will task somebody in his or her office to do that for them. And usually they're really good about it. When they're not, though, it can create a problem with your disclosure that somebody could pick up on. As Cynthia pointed out, our website is accessible, but it's accessible by the public too. So your quarterly filings are accessible, as are the pre-certification requests you've had. And we have had journalists or other interested people who will look at the pre-certifications and say, this principal and this lobbyist had an educational event down in Point Clear. Then they'll look at the quarterly filings. I know the rooms down at the Grand Hotel are X amount. They didn't disclose any of that in their quarterly filing. We get a letter saying, why hasn't lobbyist A disclosed this in the quarterly filings? Our response is, I don't know. The assumption is that they didn't spend in excess of $250 within a 24-hour period. So then Vicki or I will have to follow up with the lobbyist. It has occurred before when they've said, so-and-so in my office just failed to put that down. Well, that then becomes a problem for you if a story's been written about you that you didn't disclose. And then later, when it says that we gave you an opportunity to refile your quarterly filing, and now we're the bad guy because we let you then refile. Well, we're going to let you refile if what you filed was incorrect. But you could save both of us a lot of heartache if you would just review it yourselves. And remember, if you have requested pre-certification, remember that if you spend more than $250 within a 24-hour period, you have to disclose that. And if you've got questions about how you split that up, we've got an advisory opinion about that. If you're still unsure about it, you can ask us, but ask us ahead of time, and we can tell you whether you have to disclose that or not. We have had Vicki follow up with principals and say, as we've gone through the list of pre-certifications for the previous quarter, we've gotten her to send an email that says you had a pre-certified event and it looks like it might have generated expenses of more than $250 per attendee in a 24-hour period. Do you need to put that into your disclosure? Obviously, this year, they all got canceled, so we haven't had to worry about that this year, this past year. But just remember to keep that in mind about your disclosures and review them yourselves. Remember the 10-day rule for pre-certifications. It is not a fun email or call for us to have to say you requested on 9 days notice, and by administrative rule, we can't approve it. Because that puts you in a bad position with your principal. It may put you in a bad position with other lobbyists who you're coordinating this with, and they were expecting you to request pre-certification. We don't want you to have to reschedule it. We will tell you that we're not telling you can't have the event. There's nothing that says you have to get an event pre-certified, but it would just make it easier if you could just remember the 10-day rule. And remember to ask questions, and if in doubt, call Vicki Manning. Does anybody have any questions about any of the information that we've gone over? Yeah, that about the lobbyist registration.
Yeah, I think it's something we should answer informal. But you tell me.
I'm probably going to go ahead and answer that since this is lobbyist training. All right, Vicki, I'm going to have to get you to chime in on this one, okay? Can you come down just a little bit so at least people in the room can hear you? And I just want to see if you have run across this before, because I suspect you have, and I think I know what the answer is. But I want to make sure that we are giving out consistent advice about this. The question is, if registered as a principal who employs a lobbyist, is the principal allowed to perform lobbying activity such as meeting with legislators or testifying? My short answer to that would be is that if you're lobbying, you have to register as a lobbyist, okay? And what that means is if you are advocating for the passage or defeat of legislation, then that technically is lobbying if you're paid to do that or it's a part of your a substantial part of your job duties. However, there is an exception to giving general information to a committee or to a group of legislators. So if you want to do that, what you should do is write us and ask for an informal opinion about whether you need to separately register as a lobbyist. What I can tell you is that simply being registered as the principal doesn't insulate you from the restrictions applicable to lobbyists if that is in fact what you are behaving as. So the next question, have you ever come across that?
I haven't.
Okay. So and is that answer satisfactory for you, General Counsel?
It is.
Okay.
Yes.
All right. The second question, if not, and lobbyist registration is required, can the principal and lobbyist registration be the same person?
Yes.
The answer to that is yes, and there's nothing that prohibits you from occupying both positions, and in fact, the code tells you that you can be both, a principal and a lobbyist. But the takeaway here is that if you are lobbying, you have to register as a lobbyist. And if you are not sure whether your conduct crosses over into that, then you should ask for an informal opinion. And thank you for that question. That was a good question. Any other questions, either through the webinar or in the room? And y'all, 45 minutes. That ain't too bad, okay? Is there something I missed?
I don't think so.
All right.
Tell them to click the button at the bottom of their screen and submit their thing, because they have 20 minutes to get that in.
Okay, Vicki is telling me to tell you to be sure to click your button at the bottom of the screen, and you have 20 minutes to do that. That confirms your attendance here today. Let me see, I just got a text. Let me make sure it's nothing I need to bring up. No, it was from 901-268-1846. Okay, great, very helpful. I'm glad it was 1846. I'm glad it was helpful. So just know that if any of you have any questions after we leave today, you know who to go to. You can ask us or you can ask Vicki. We appreciate your time. Thank you for what you do, because your service is important to the state, because you're subject matter experts on the things that you lobby, and it is helpful to the decision-making process. So if we can help you through that in a way that makes it less fearful for you moving forward, that's what we're here to do. So thank you very much, and y'all have a good rest of the day.